Hello, and welcome to Connected with Latham, where we discuss ideas, legal developments, and business trends shaping the global economy. I'm Beatrice Lo, an M&A partner in Latham & Watkins London office. So today, we're going to be discussing the increasing focus of regulators on both sides of the Atlantic towards restrictive covenants and non-competes. And I'm joined by my brilliant colleagues, Nineveh Alkhas, a partner in our Chicago office, and a member of our executive compensation, employment, and benefits practice. I'm also joined by Karima Salway, a senior M&A associate, also in our London office. Nineveh, Karima, welcome to the podcast.
I'm thrilled to be here, Beatrice.
Thanks for having us on.
So to start off with, what do non-competes and non-solicits mean in the context of M&A and employment? Karima, do you want to kick us off with the M&A context?
In an M&A context, an acquisition document will typically have a clause which restricts the seller from competing with a business which has just been sold to a buyer, and that clause will be effective for a certain period of time, and that's a non-compete clause. A non-solicit or no-poach clause will restrict the seller from hiring or soliciting employees working for the business sold for a certain period of time, and you also see a non-solicit in respect of customers and or suppliers.
In the employment context, a non-compete clause restricts employees from competing or working for another entity that competes with the employer's business, again, for a certain period of time after their employment or engagement has ended. A non-solicit, on the other hand, is an agreement whereby the employee agrees not to solicit their employer's customers or employees. So they're not restricted from going to work for a competitor, but they are restricted from soliciting certain customers and employees. A non-hire or non-poach agreement goes a little bit further by imposing an obligation to not hire the employer's employees. In particular, when the no-hire or no-poach agreement is between corporations, this can raise antitrust concerns. This has been particularly a high-risk area given heightened U.S. criminal enforcement.
Right, so why don't we start there? So speaking of the heightened enforcement you mentioned, Nineveh, I understand that the US Federal Trade Commission has proposed a new rule relating to non-competes, which would ban them in most situations, arguing that, that poses an unfair method of competition. If that rule were to come into force, how would that impact employment contracts?
The proposed rule by the FTC would effectively prohibit employers from entering into an agreement with an employee or a contractor, limiting their right to seek or accept employment after their engagement ends. So it would apply to traditional non-compete agreements in that sense. The proposed rule would not expressly prohibit other forms of restrictive covenants, such as non-solicit covenants or non-disclosure clauses. However, broadly drafted non-solicit or non-disclosure clauses, just as an example, could be considered an unlawful de facto non-compete clause, which the proposed rule does restrict, especially if a clause effectively precludes a worker from operating a business or seeking or accepting employment after termination. It will act like a true non-compete, and under the FTC's proposed rule, that would also be prohibited. The FTC's proposed rule would apply to new agreements as well as pre-existing agreements. In fact, the proposed rule would require all U.S. employers to rescind existing non-competes within a certain time frame after the rule takes effect. It would also significantly limit the use of deal-based non-compete clauses, with only a couple of very narrow exceptions. Meanwhile, several U.S. states already have or are seeking to put in place complete or partial non-compete bans, and thus careful deal analysis and detailed advice from legal counsel will be required when evaluating the inclusion of non-compete clauses in any context.
Right. And then what about, Karima, in Europe and in the UK? Are regulators also focusing their attention on non-competes and non-solicit clauses in the same way?
They are. And let's take Europe first. So it's interesting to note that in Europe, employment laws are typically more favorable for workers, and they've had strict conditions for the validity of non-compete clauses for quite a long time. So, generally, for a non compete to be enforceable in Europe, employees must receive appropriate compensation during their post termination period. Looking at no-poach clauses, so these two have attracted attention from the European Commission, their concerns being the impact on wages and the movement of labor. And the Commission has signaled enhanced enforcement on no-poach agreements, and it has imposed fines on companies in various jurisdictions and sectors, which have ranged from a couple of 100,000 to a couple of million euros.
Oh, wow, that's a lot. Yeah. But then what about in the UK?
So in the UK, let's go back a couple of years, and there was a government consultation from December 2020 to February 2021, and that looked at the use and possible reform of non-compete clauses. So that consultation has concluded, and the government responded in May of this year when it announced that it would legislate to limit the length of non-competes to a maximum of 3 months post termination. So we don't know when this new law will come into effect, but what we do know is that it won't affect or limit the use of non-solicitation clauses. It won't affect paid garden leave, notice periods, or confidentiality clauses. And it will only apply in contracts of employment, so it won't affect non-competes in wider workplace contracts like shareholder agreements. What we don't know if it will have retrospective effect like the proposed FTC rule, which would reduce the time period of existing covenants.
And what about the CMA? Have they come out with anything on this point as well?
They have. The CMA in the UK has also demonstrated an appetite for enforcement. And in February of this year, it issued guidance to employers on how to avoid anti competitive behavior, looking at unlawful poaching, wage fixing, and information sharing. And this guidance followed an investigation in July of last year, which looked at alleged wage fixing for freelance technical staff.
Right. So I actually get asked this question a lot from clients about how they, can protect their goodwill in a business they're buying and how they protect themselves if senior management were just to leave and join another competitor and take away, the rest of the team with them. And then typically what we do is, include a restrictive covenant like these ones. But it sounds like, with the increased regulatory scrutiny, we really do have to be a lot more careful. Karima, do you have any suggestions for our clients who are asking those types of questions in the M&A context?
Yeah, and it's a really good question, especially now. It's quite obvious that we do need to pay more attention to this. In the UK, we have the long standing enforceability test, and we expect that will continue to apply. So it's important for deal teams and clients to consider when drafting a restrictive covenant that, first of all, the covenant is designed to protect legitimate business interests, and also that it goes no further than what is reasonably necessary to protect those business interests. So looking at scope, duration, and geographical reach. And they should also pay attention to when restrictive covenants become active. So if there's a gap between signing and closing, and if there are restrictions on seller during that gap, if there are any restrictions on an employee's movement, those should be reviewed to ensure that they don't give rise to gun jumping.
Hmm. And Nineveh, what about in the US? Is there something we should be looking at there to make our non-compete, non-solicit clauses sort of more enforceable in the context that you discussed earlier?
Definitely. In the US, reasonable sale based non compete covenants are generally permitted in most states. Nevertheless, those covenants should be appropriately tailored to the activities and the geographic scope of the sold business at the time of the sale. Under the proposed FTC ban, there is also an exception for non competes entered into upon a sale of a business. However, that exception is very limited and would only apply where the restricted party is a substantial owner, member, or partner in the business entity. And by substantial owner, the proposed rule would require that the seller have at least 25% ownership interest. Acquirers will need to be vigilant here when negotiating non-competes and mindful of this 25% ownership threshold, which could or could not be met in many cases.
Hmm. Then what about outside of the M&A context? If you are an employer and looking at ways to mitigate the risk of violating current or future regulation in this area, is there something we would suggest our corporate clients do? Nineveh, should we start with you in the US?
Sure, Corporations should review employment and other related agreements now for provisions that may constitute violations of state law or draw scrutiny from the FTC. For example, in light of antitrust concerns, corporations should review provisions or discussions that are not memorialized in writing that could raise issues. For example, a discussion that seeks to restrict the solicitation or hiring of employees from competitors, that prevent competitors from soliciting or hiring their employees. Other examples include discussions that could limit competition over their employees' compensation, or other discussions that could be pursued as criminal offenses in the US. Employers should comply with all applicable state rules, or else the covenants may be not only void, but also unlawful and give rise to liability.
Karima, are there any top tips for the UK employers?
So thinking about the legislation that is expected to come into force, because we don't know when that will come into force, for the time being, non-competes of over 3 months are enforceable, provided they're no wider than reasonably necessary. So corporates can therefore continue to include longer non-competes in their contracts. But of course, be aware that agreements exceeding 3 months may have to be revisited in the future. So gardening leave may be considered as an alternative tool for managing the departure of key staff. And similar to the US, corporates should review their HR policies to ensure that they comply with competition law and update their HR training to ensure that such training addresses competition rules relevant to employees.
That was incredibly helpful. There are some really good tips there and action points for our clients and for deal makers looking at M&A. Thank you, Nineveh and Karima, for sharing that with us. And thank you both for joining the podcast.
Always a pleasure, Beatrice.
Wonderful to chat with you today.
And thank you, listeners, for joining us on this episode of Connected with Latham. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Google Podcasts, Spotify, or wherever you normally get your podcasts. If you'd like more information about the topics in this podcast, please do email us from the links located in the show description. We hope you'll join us again next time. Thanks very much.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.